Away from the confirmation of the CJN, let's turn our attention to the situation with the Edo State House of Assembly.
Please, can you tell me why only 9 of you?
Last week, following a motion of urgent public importance calling on the House of Representatives to intervene and help forestall a constitutional crisis in the State House of Assembly, the ad hoc committee, which investigated the crisis, laid its reports before the House. The recommendations of the committee are that the governor of Edo State should issue a fresh proclamation within 1 week, that all actions taken by the 7th Assembly should be declared null and void pending proper inauguration, that all members of the House of Assembly should dissolve their factions, and that the Inspector General of Police and the Director General, Department of State Services should shut down the Edo State House of Assembly and provide adequate security to allay further fears of intimidation and threat as alleged by members-elect. The House adopted the recommendations and resolved that if it's not implemented, the National Assembly will take over the Edo State House of Assembly as stipulated by the Constitution. Law Weekly sought the views of some senior lawyers on this update.
With regards to the resolution of their factional issues, that's a political matter. That doesn't concern the law, technically, so that's a private matter of the APC. But however, with regards to the other 3 directions, the direction to the governor, the direction to the IGP, and then the direction as regards the nullity of the actions of the Edo State House, with great respect to the House of Representatives, they do not have the power to issue those directions. With regards to the proclamation, the power to issue a proclamation by the Constitution inures to the governor personally. Now, there is no provision of the Constitution that allows the House of Representatives to impede on the power of the governor, if you put it that way. The only intra-constitutional limitation on that power is that the governor is to issue it immediately after he's sworn in. But we all know in the situation of Edo State, it's a bit unique because the governor was sworn in about 3 years ago and he could not have issued a proclamation 3 years in advance. So that does not apply. And as such, the House was exceeding its powers in that respect. With regards to the directive to the IGP and to the DG of the DSS, the House of Representatives does not have that power. The power to issue orders to the IGP is limited is given constitutionally to the president or to his lawfully appointed minister, while the power to issue directives to the Commissioner of Police is given to the governor or his duly appointed commissioner, subject of course to reference to the president. So that power does not belong to the House of Representatives, and they could not have exercised such a power. And then the question as to whether or not the actions of the House of Edo State is, as of presently constituted, is void, that's a judicial question. That does not lie within the powers of the House of Representatives. That is wholly and completely a judicial question that would, of course, be subject to the court's direction. But more importantly, it's important to state that by Section 168 of the Evidence Act, as presently constituted, since the Edo State House is a public body, there is a presumption of regularity with regards to their appointment and with regards to their actions. So as of now, legally, all they have done is presumed to be regular, subject, of course, to a court directive that what they have done is not regular.
If we agree that there is a constitutional crisis, now the convenient starting point in addressing the issue would be for the National Assembly. The National Assembly is incomplete without the Senate, but what we have now is a resolution by a junior half of the Assembly, if you like, the House of Rep, Green Chambers, mandating a committee to come to Edo State to take over the House of Assembly. We don't think they have that constitutional power. There's nothing in the Constitution that gives them that power. The Constitution talks about the National Assembly in Section 11, and the National Assembly is a combination of the red and the green chambers. I believe the House of Representatives acted ultra vires in the resolutions that they came up with. First of all, there's a matter in court in which the clerk of the House and the as Edo State House of Assembly has sued the chairman or a member of the National Working Committee of the party, the Inspector General of Police, and the Edo State Police Commissioner. If there's a case in court, and not just a case in court, I'm aware that there's an interim order as well preventing these persons named as defendant in the suit from taking over the functions or do anything to disturb the business of the House of Assembly in Edo State. If that is the position, then the best thing for the House of Rep to probably do is to join that suit as co-defendants, so they can go there and ventilate any grounds they have against the governor and the House of Assembly in Edo State. For them to order the governor to issue a second proclamation, I don't think they have the right to do that, because the Constitution does not allow for a second proclamation, if you like, and they are not a court of law. They cannot nullify the actions of the State House of Assembly. They don't have such powers.
And just before we go, two senior advocates of Nigeria, Femi Falana and Jubrino Kutepa, have been speaking about the need to handle election petition cases better. We have their opinions up next.
Right now, or whenever we have elections, our courts are compelled to adjourn cases because election petitions have to be dealt with expeditiously. For me, there is a problem. For instance, not less than 350 judges, High Court judges, serving in the state high courts, in the federal high court, and in the National Industrial Court, have been pulled out of the system and transferred from their jurisdictions to other parts of the country, at least for 6 months, 180 days. And for cases that are pending in those courts, the cases that are pending in those courts are just sine die. And we are normally told the judges have gone on national assignment. And I have repeatedly asked, are you saying the other cases are not part of the national assignment for which our judges have been appointed? Since litigants are equal before the law. In fact, our law prescribes that fundamental right cases shall take precedence over all my other matters. If a court now places premium on election petitions to the detriment of fundamental right cases, there may be a problem. I am therefore of the opinion that, number one, we have to go back to the pre-2011 situation, whereby all election petitions were handled at 2 stages. Either from the Election Petition Tribunal to the Court of Appeal, and that would be the end of the matter. Or with respect to presidential elections, the petition will commence at the Court of Appeal and end in the Supreme Court.
I'm of the view that there is a deliberate effort on the part of the political class to deny justice to the ordinary people. If you slap me, I slap you today, and the matter goes to High Court, its possibility exists that the court to which that case is assigned may be moved to adjudicate on an election petition. As of today, Nigeria has in its reservoir some of the finest brains who have been compulsorily retired because they have reached the mandatory age of 65 for the lower court, 70 for the Court of Appeal and Supreme Court. If you see a 70-year-old man that retired from Court of Appeal and Supreme Court, for instance, they are still ill and hearty, mentally alert. They have the jurisprudence of election matter at their fingertip, so they know what is good, what is right. So the fear of some people that how do we discipline them if they misconducted themselves is misplaced. Because A retired judicial officer is still a legal practitioner within the meaning of the Legal Practitioners Act. If a retired judicial officer, for instance, sitting on election petition tribunal, misconduct him or himself in a manner that is unprofessional, in professional respect, he can be reported, for instance, to the Legal Practitioner Disciplinary Committee for purposes of removing his name from the roll. But we try to put obstacles on our way sometimes where there are no obstacles. My suggestion is that we should amend our constitution to make retired judicial officers to head election petition tribunals, and then other legal practitioners of impeccable character and conduct, not legal practitioners that can be bought over like Esau in the scripture, just with a pot of porridge.
And that's the program this week. You can watch it again on our YouTube channel. Kindly give us feedback via any of our social media handles. I'm Shola Shayeli. Thank you for watching.